Most criminal justice systems break down the type of offense between felonies and misdemeanors, and then there's also often things below misdemeanors, which are sometimes called infractions or violations. And it varies by jurisdiction, but in most places, a misdemeanor is something that's punishable by a year or less in jail, whereas a felony is punishable by prison. And essentially what that just reflects is an ordering of the seriousness of offenses. So you think that you punish more harshly offenses you think are more serious. Here in New York City, in the New York State, that's our definition. And in New York City, like in most cities, the most common arrests are for misdemeanors and not felonies. And that increased dramatically over what we call here the broken windows period, or the broken windows era. So starting in the mid-1990s, the New York City Police Department, the NYPD, instituted a set of basically tactics and policing policies that said, we're going to take really seriously low-level offenses. And they did that because they believed two things. One, that there was a sort of kind of what one might call a developmental sequence or a causal relationship between tolerating low-level disorder or low-level offending and serious street crime, which in the 90s was a very, very serious issue. There was a very, very serious crime wave that had been happening really since the 80s through the mid-1990s. And then the other theory was that people really cared about low-level offenses and low-level offending. They cared about disorder. So under these twin guideposts, the NYPD instituted something called broken windows policing or quality of life policing that dramatically increased the number of misdemeanor arrests in New York City. Over that era, one of the most common expectations probably most people would have had is that what would happen would that people would be punished, that they would be convicted and probably sent to jail. Because when we've had other expansions of the criminal justice system, that's one of the more common things we've seen with the war on drugs meant that we were going to arrest more people for drugs, but we were also going to convict more people and send more people to prison. But what's interesting about the New York City experiment is that that's not what happened. What happened over this era is that as the lower criminal courts were fed ever higher volumes of low-level cases from this form of policing, the misdemeanor conviction rate went down, so the proportion of cases every year that terminated in a criminal conviction decreased, and the dismissal rate, so the proportion of the cases that terminated in some form of dismissal, went up. One might think of the broken windows policing era in New York City as the mass misdemeanors, sort of like as to borrow the phrase and change it a little bit that we talk about with mass incarceration. But mass misdemeanors, like mass incarceration, aren't mass in the sense that they're widely shared and experienced widely in the same amount, in the same way amongst all communities. The increase in misdemeanor arrests in New York City has largely been an increase in arresting Black and brown Hispanic men. Not exclusively, but that's been the biggest increase. So it's concentrated on people that are in those spaces also. So part of the reason that you see those distributions is that the NYPD concentrates its resources in Black and brown communities and Black and brown neighborhoods. What that means is that there's a huge disparity in the amount in the arrests, perhaps even conditional on some underlying conduct. That's something that's very hard to know, but for the biggest arrest categories over the city's history, which for most of the broken windows era was marijuana possession, the rate at which Black and brown versus white people use marijuana is not vary, but the rest were almost exclusively of Black and brown men. And you see that in some of the other arrest categories. One of my key findings in the book is that contrary to the expectations of how we teach that criminal courts work in law schools, or the way that you might learn it from watching popular culture, like TV shows, Law and Order, are that courts' job is to decide between all those people that the police bring in, who the police have accused of committing a crime, that they say they did something on the list that the criminal law lays out that says you're not allowed to do. The way that we think of courts working is that they sit between that and punishment, which is typically conviction or jail time or a fine. And the job of the court is to say, all right, well, we have to use criminal procedure, which are all the rules about how you decide whether or not someone is guilty, to figure out if this really happened, if the person that's accused of doing the thing has done the thing. And to use a fancy word, we could call that the adjudicative model, meaning that they're trying to adjudicate between guilt and innocence. However, in New York City's criminal courts in this era of broken windows policing, that's not how the courts are operating. And one of the first metrics to prove that is that somewhere between 50 to 60 to 65% of New York City's misdemeanor cases terminate at arraignments. So that an arraignment is the very first court appearance that you have after you've been arrested, usually within 24 hours of your arrest. You're taken in front of a judge, the charges are given, and we think of that as being the time where bail is set or not, and that it's true. But in New York City, the majority of misdemeanor cases actually terminates right there at the very first court appearance, which means all this stuff that we teach in law school and all this stuff that you've seen in the movies happen where there's an investigation and there's legal motions filed as to whether or not it was lawful that the police made the stop or they did the search, and there's witnesses testifying between contesting versions of the events, that just doesn't happen. In fact, in New York City, the trial rate is less than 1%. Meaning that at the height of misdemeanor arrests, when there was something about close to 250,000 misdemeanor arrests, that's 250,000, there was less than 1% of those cases ever went to trial. So that's just not how our system works. It's not a system of trials, but moreover, my claim, we've known that actually with respect to felonies. So the trial rate in felony courts is pretty low too. In most states and in the federal system, you might find it between 4 and 8%. So it's very low in felonies too. But what's different in misdemeanors is that there isn't really even this attempted adjudication. The majority of these cases, they go to disposition not on the basis of someone having fought out what really happened. And that's not really even what the prosecutors are often going for. Instead, there's what I call this managerial model. And that might seem like a weird term, but what I mean is that the criminal court actors are using the tools of criminal procedure and criminal law to test people, to mark people, to check up on them, and to sort of build records and about the type of person that they think they are. So it's more about judging and assessing the type of person that's in front of them and whether or not they think that it's a person that they can let to go back out there in the world, or if it's a type of person that they want to keep control over. Now you can see how that might correlate with whether or not someone has committed an offense, but the truth is it doesn't always. So in many cases, if it's in a first arrest and it seems, given the officer's account, that it's more likely than not that the prosecutor believes the person actually did it, that doesn't mean they're going to try to look for a conviction. Often what they're going to try to do is simply say, okay, I will adjourn this case for 6 months, a year. I'm going to require that you maybe do a day of community service, or that you enroll in this program, or just that I'm going to see if you get rearrested. Afterwards, the case will be dismissed and sealed. And so what that means is that it's not that during that time they're trying to use their investigative powers to figure out what really happened or send more police officers out there to investigate or file motion practice about the legal issues. Instead, what they're trying to do is figure out what type of person they think they have in front of them over time. The most important thing you've got to understand about our criminal justice system is it's really not an adversarial system in the way that we think of it anymore. It's what we could think of as a quasi, maybe administrative or inquisitorial system, which are just fancy words of saying that there's one office that's charged with both deciding whether or not they want to charge and deciding if they think the person is guilty, what they want to do, and what the sentence should be. And that office is the prosecutor. And that it's just very, very rare that cases terminate because there's been some adversarial proceeding where there's a neutral decision maker, whether that be a judge or a jury deciding it. A number of areas that this research brings me to think that we should focus on. One is an area that a lot of people have been talking about, and that's true not just in misdemeanor court, but in felony court too, which is the power of the prosecutor and how we want to, as a democratic society, control that. So the shift from adjudicative, a trial-based system to one that is almost exclusively run by pleas is a shift, and also mandatory minimums and sentencing guidelines, which, as we know, aren't mandatory in New York and aren't mandatory anymore in the federal system, but still play a big role, has largely been a shift of moving the power to the prosecutor, because the prosecutor has the power to choose the charges, to choose whether or not he or she or they think that they want this case to go forward, if they think the person is guilty, and what sentence they want. And so we need to think very carefully as a democratic society what tools we're comfortable giving the prosecutor to do that, and what discretion we're comfortable with them having, and where we might want checks, and where we might want to actually give some power to the defense, or say, you know what, we're not going to allow certain practices. We're not going to allow you to threaten a prison sentence of a charge that is almost impossible that you could ever prove beyond a reasonable doubt in order to get a lesser plea. We're not going to allow you that type of leverage. So this is an important question, first of all. The second, of course, would be what I mentioned before, which is the way that this level, the criminal justice system, is less about this permanent change. You're convicted, you have a felony conviction for the rest of your life. And that's an important thing that happens in a certain component of the criminal justice system. But what happens in the lower end of the criminal justice system is often cycling in and out of different statuses and having to come back to court. So we have to think about how we want to have criminal law administration work. We could streamline courts. We could not require as many court appearances. You could give more funding to the different components of the criminal justice system, the defense, the court actors, in order to not have such a long backlog. Fines and fees. It's been a tragic move, I think, over the last 30 years to shift the cost of criminal law administration onto the backs of the users. And I think that's a deeply, deeply flawed model. So mandatory surcharges, victim assistance fees, parole supervision fees, all this stuff I think is deeply, deeply misguided. Civil forfeiture, I think all that needs to be revisited.